9-0 Sustr versus ATX Tillery and Meandering Bend LLC.
Your Honor, Attorney Jennifer McGeorge here for defendants ATX Tillery and I'm sorry, Meandering Bend.
On behalf of plaintiff Paul Sustr.
Who is that speaking? Because wasn't very clear.
Wendy Chen speaking on behalf of plaintiff Paul Sustr.
Okay, Ms. Chen, we're going to have to work on your audio because you sound real far away. How much time do you all think you're going to need for your hearing today, please?
Well, Your Honor, they originally, I think there's some issues with which is set and which not today. But I think that the traditional motion for summary judgment is set today, and it should take us no more than an hour.
Ms. Chen, do you agree with that time announcement?
Your Honor, my understanding that we had discussed both motions, but
well, I've looked at the file. There's a problem with when the notice was given on the no evidence. We'll take that up. But so, all right, when I get to you, thank you. I think I'm going to take up I have shorter matters that I may take up first. For Cougar LLC versus Principal Renovations LLC.
Yes, Your Honor. Brian Erickson for the plaintiff. I anticipate about 5 minutes because I don't think there's any opposition.
I looked at the file and I think you're right. So thank you, Mr. Erickson. Pettis versus American Wind Transport Group LLC and Stephen.
Your Honor, Mauzy on behalf of the defendants, Daniel Stephen, American Wind Transport Group, and Stephen Family Farm.
Luke Dow, guardian ad litem for the minor.
Who else is here on that case? Plaintiff's counsel, is plaintiff's counsel here? And do we have a witness?
I see the witness, I think.
Yeah, Ms. Pettis.
Yes.
I'm going to ask you all, I'll call through looks like we need to find Ms. De Leon. So if y'all want to mute yourself or turn off your camera and somebody give her a call, I'd appreciate that. Assuming we can get her, how long do you think? What's the time estimate, Ms. Posey and Mr. Dow?
Under 10 minutes.
Ms. Posey, you agree with that?
Say 10.
Okay, thank you. Why don't you go ahead, Mr. Dow, and try to contact
I will.
plaintiff's counsel. Thank you. Navarro versus Rodriguez, Stallworth, et al.
Kenny Rubel, counsel for, and I'm going to change my name. I realized it's from this morning. I'm counsel for defendant Unitran and movement of the motion. I anticipate 30 minutes.
Yes, and I'm Allison Reyes, attorney for plaintiff.
And you agree with that time estimate, Ms. Reyes?
Yes, Your Honor.
Okay, thank you. I'm going to ask you, I'm going to take up cases one at a time. Again, the short matters, I'm going to start with 5704 Cougar. Everyone else who, I'm going to ask you if you turn off your camera down at the bottom left so I can see who I'm dealing with in a bigger box. Thank you. Mr. Erickson.
Yes, Your Honor. I want to especially thank Ms. Chambers for working to get me a Zoom link. She went above and beyond. So thank you, Ms. Chambers, for doing that.
And thank you for recognizing that. I appreciate it. And I know she does too. You got us reassigned to us this morning. I understand. Yeah.
Yes, Your Honor. 5704 Cougar is the owner of a construction project in Austin. The principal contractor was Principal Renovations, and they were terminated for doing lousy work. And eventually, the plaintiff filed this lawsuit, 5704 Cougar, and the defendant, Principal Renovations, filed a counterclaim, and they also filed a mechanics lien and an amended mechanics lien. We tried to get support for the defendant's claim. And as we were trying to do that, the defendants lost their attorney. They withdrew with the court's blessing. And it's left the defendant contractor alone without an attorney. And he's been totally non-responsive through this course of this case. I had to get a process server to serve the agent for servicer process for principal renovations with notice of this suit, notice of this hearing. And that happened. Service was affected on November 4 on Douglas Morton, the agent for servicer process. And that affidavit of service was filed with the court on November 12, 2024. So the defendant got notice. They haven't filed a response. And basically, this is a no evidence motion for summary judgment because the defendants just have failed or refused to produce any documents to support their claim, their counterclaim. And their counterclaim is sizable. It's over $329,000. And so we filed this, addressed each of the claims in the defendant's counterclaim, and they got 7 types of claims. And in our motion, we addressed each of them. The defendant filed no response. They haven't produced any documents to support their claim. Our no evidence motion for summary judgment was focused on them not having any evidence to support that they were entitled to any money, and they haven't refuted that. So with the court's blessing, I would ask that the court grant the proposed order granting plaintiffs no evidence motion for summary judgment that I have tendered to the court yesterday.
Thank you. Where did you tender that proposed order?
I e-filed it, Your Honor.
Okay. I would bet, Mr. Erickson, I'm looking. Yeah, if we don't like in the future in Travis County, let's don't e-file orders. That didn't help. So I'm going to ask you to send it to my submission email address. It hasn't made it to my file in any event. It takes more than a day. My submission email address is my court number 419.submission singular at Travis County TX, spell out Travis County and then TX.gov. Oh, and Ms. Chambers is telling me now the clerks are kicking back unsigned orders. We don't want unsigned orders in our file. We work on a central docket system here, not like you do in Dallas. So nobody would ever see it anyway. But if you get me an order, I reviewed the file before I took the bench and I see that there's no response on file. So I will grant your no evidence motion for summary judgment as soon as, and I'll sign the order as soon as you get it to me.
I will do that. Thank you, Your Honor. Am I excused?
You may be excused. Thank you, sir.
Thank you.
All right. I would next take up the Pettis matter if Ms. De Leon has been reached. I'm trying to get the shortest matters out of the way first.
Your Honor, I think we're waiting on Mr. Dunn. I don't see that he's appeared just yet.
Okay. Thank you. Then I'm going to go move to Navarro versus Rodriguez Stallworth, Unitron County Mutual. So again, for the record, please, appearances.
Your Honor, this is Kenny Rubel. I appear for defendant Unitron, the movement, I'm sorry.
Your Honor, my name is Allison Reyes and I'm appearing for the plaintiff.
Okay, I don't typically have my court reporter take a summary judgment, but I do note, am I right, that when I looked at this before, that this case has some objections? I'll take a record on objections if we want to deal with those first. Am I confusing that with another case I've got today? Nope, there aren't any objections on file, right?
I don't have any.
All right, Ms. Primo, you don't need to take a record on this. All right, Mr. Rubel, if you'd like to proceed with your argument, please, sir.
Yes, Your Honor. This incident, this lawsuit, the basis of it is an accident that took place on July 3rd, 2021 in the 6th Street Entertainment District underneath the highway I-35, the parking lot there, apparently. On the eve of the 2-year limitations for torts, the original petition was filed in May 16th, 2023, right? I'm sorry, somebody just interrupted me. I'm sorry. The petition was filed May 16, 2023. Defendant Unitron, who was named as a UIM carrier, answered on June 22, 2023. And we've served the initial disclosures, discovery request, did not receive anything in return. There is no discovery level control plan, so it defaults to a level 2. Because of that, the initial disclosures were due on July 24th, 2023, and 9 months later, per Rule 190.3, the discovery was closed on April 24th of this year. 6 months after that closing, we have filed a no evidence motion for summary judgment on October 24th, 2024. Plaintiffs filed a response to our motion on November 13, 2024. However, they do not present any sworn testimony, any evidence to establish the challenged elements of our no evidence motion for summary judgment. The hearing was noticed on November 26th, and we are here today asking the court to sign the no evidence motion for summary judgment, as plaintiff has not been able to respond and present to the court even a scintilla of evidence that would justify the cause of action proceeding further against the defendant and movement Unitran.
Thank you. Ms. Reyes?
Yes, Your Honor. So there are multiple defendants involved in this claim. There's 4 total, one of which has not responded at all to the lawsuit, one who we are pending a motion for substitute service on it because the defendant on that one is actively evading service. And so there's 2 parties that have not responded other than defendant Unitran. And so without having all parties present, it's hard to conduct discovery because we would just be doing it over and over again for different parties. And it wouldn't make sense to just start discovery with one party when we have one party that has not responded and one party that is telling us they don't want to respond to the lawsuit. Or I'm sorry, one who has not responded and one who has not been served appropriately. So discovery can't be completed with all the parties. Now, as far as presenting at least
Let me ask you a
Yes,
question.
Your Honor.
Verbal tells
Yes,
me
Your Honor.
that this defendant that he represents has been served, and weren't your disclosures due whether or not the other defendants are served?
Yes, Your Honor. And our disclosures were served to defendant Unitran on July 12th of 2023.
Okay.
Yes, Your Honor. As far as the evidence for the claim against defendant Unitran, part of those elements have to be established against the original at-fault party, which is the specific defendant that is evading service. And that's where we have that motion out pending review for substitute service, because we do have confirmation that he is aware of the lawsuit, but is evading actually being served. So that's something that we need to establish, and we can't do so without that defendant being part of the lawsuit. So we can't get to the elements against defendant Unitran as stated in their motion until we get that part settled as well, or attempted to resolve as well.
You filed a motion for substituted service in April. Why haven't you done anything about it?
Yes, Your Honor. So we were following up. There was some confusion with the procedure with getting it submitted to the submissions email. So it had to get resubmitted so that it was following appropriate procedure. And I believe my paralegal has been trying to follow up, but it's kind of gotten delayed. I will apologize for that, Your Honor.
Well, I do think at this point where your submission is in a court that the judge is leaving the bench at the end of this month, and I don't think is sitting anymore. So, but
okay, I will make a note of that, Your Honor.
That really doesn't excuse between April and December. You can always set a hearing if you can't get something on submission.
Yes, Your Honor, and I will be doing so. I also just filed my notice of lead counsel earlier this month, so I apologize to the court for that and for the time that has taken, but that is something that we are looking to do for that particular defendant. However, we don't feel that it would be fair for the plaintiff to not have their case heard against all the parties, given that it is so complex with how many people are involved, to have it dismissed before we're able to really get into the discovery part of it. And I realize that time has passed. But again, with the complexity of everything and making sure that all the parties do have notice of this lawsuit, I don't feel that it would be in the plaintiff's fairness to dismiss her case.
Well, I have to think about fairness to all parties, and I'm looking at a lawsuit that's been filed in May of 2023. And here we
Yes,
sit
Your
in
Honor.
December of 2024.
Yes, Your Honor, I understand. Even so, I can say that we can get everything moving a little bit faster now that I've gotten some new information, which again is my apologies to the court for that, on that judge that is no longer going to be with the court, but I can get all of that taken care of by the end of this month. Or sooner if the court would prefer. I realize a month is actually way too much time.
Yeah, it really is. I'm going to hear from you, Mr. Warble, but is that what you have to say about this, Ms. Reyes?
I'm sorry, I think it cut out.
I said, do you have anything else you want to add by way of your argument?
I mean, other than the biggest thing is for defendant Unitran's claim that we can't prove even a scintilla of evidence, I would argue that that is incorrect. It was proven in our disclosures that at least the damages that are asserted in this case won't be covered solely by the policy of the at-fault driver.
Do I have any summary judgment evidence attached to your response that tells me that? I don't see it.
It should have been, there should have been a police report. As far as element 1 for proving fault on the party, it should have been a police report that was attached to the motion. I can definitely double check it, but it should have been attached.
Hold on. You need to double check it. I've got your response. Okay. It is precisely 6 pages, and the 6th page is the e-file notice. The 5th page is a certificate of service. There is no evidence attached to your response.
I am not finding it, but if that's what you were seeing, then that must be correct. But it should have been a police report along with the previously filed disclosures.
Do you have anything to add, Ms. Reyes?
No, Your Honor.
Mr. Warble.
Yes, Your Honor. Procedurally, we've put the plaintiff to the test of producing at least a scintilla of evidence. They presented some argument. There is no evidence, however, for the court to be able to find that there is any evidence, even a scintilla on the challenge elements, and no evidence granting is certainly procedurally appropriate.
It does seem, unfortunately, to be true because I'm looking at the plaintiff's response and there is no summary judgment evidence contained within the response. There's some cited case law and there's some argument. You want to send me a proposed order, Mr. Verbal? I believe I'm going to have to grant that, Ms. Reyes. I'll take a closer look, but I don't think I have any choice.
Okay, is I apologize. Would I be able to upload that to the box link for your review?
No, ma'am. Under the rules of procedure, you have to file your summary judgment evidence at least 7 days before the hearing. And you've had notice of this hearing since November 26th. Well, actually, how can that be right? How can we be going forward? Hold on. That's a problem. Did you just give notice of this on?
Of the hearing on 26th, yes, Your Honor.
On November 26th, how's that 21 days notice?
My understanding of the rule is that it's 21 days after the filing of the motion and that they have to file their evidence 7 days before.
That's true. But that's true, but
and that's my only reading, and that's from law in 1994 Blake. I got a case on that.
You need to send me that case and I'll look at the rule as well, but I don't know how they could know when 7 days before the hearing is if they didn't have 7 days notice of the hearing. Because so that Ms. Reyes, you may be lucky to be getting out of that. You filed the notice on the 26th, which is 7 days ago. The filing doesn't count, so it didn't give 7 days notice for her to.
That's 7 days ago.
You don't count the day of either. You don't count the day you file it. So
Okay.
I'll look at this, but I'm pretty sure. I have to pull up Rule 21. You either don't count the day that you sent the notice or today's date. Either way, it's not 7 days.
Last Tuesday?
Yeah,
Not
today's
7?
well.
I believe it's the 20th.
Maybe you're right. If it's filed on
Exactly.
all right, I'm
7
gonna.
days.
It may be exactly 7 days. You're right. All right, you can send me the proposed order. I'll take a look at it and get y'all rolling. But Ms. Reyes, in the future, you all
Yes, Your Honor.
be careful. I mean, you don't have any summary judgment evidence. I'm going to look at the timing, but if there's no summary judgment evidence, I don't have any choice but to grant his motion.
I understand, Your Honor. I thought that it was included, but yes, that is
Well,
on
I
me.
mean, you know what? If I'm looking at your motion and if it referred to exhibit A, B, or C, that might be a different matter, and it's something I'm perusing your motion. I don't see any reference to any exhibits. If I'm wrong about that, please point my attention to where you make reference to specific summary judgment evidence that you say should have been included.
Yes, Your Honor. I'm trying to look through it really quickly, because I was pretty certain. I mean, either way, like I said, if that's what you're looking at, I completely understand that. Let me see. Yeah, towards the bottom of page 3, I do make a reference to, quote, plaintiff's damages as stated in plaintiff's initial disclosures to defendant Unitrin, etc.
But that's not proper summary. I don't have that. That's no evidence.
I understand that, Your Honor, and I should have attached them. I thought having them already been filed with the court would have been sufficient.
They're not filed with the court anyway. We don't file discovery.
It should have. Okay. Yes, Your Honor.
Thank you all. Mr. Orville, if you'd send me a proposed order.
Yes, Your Honor.
Thank you. You all may be excused.
Thank you, Your Honor.
Are we ready on the Pettis matter? If not, I'm going to take up the longer hearing first.
Your Honor, I got in touch with plaintiff's counsel and he was sending somebody else from his firm.
Mark, there's somebody to be admitted.
Okay. Hopefully that's.
Who is that? I have somebody named Sasha in the waiting room and a Mark with no last names.
I don't know who he was sending.
Your Honor, I think that might be parties to our case, to the longer hearing. Sasha and Paul.
Who's this? I have a Mark. I need anybody who's in the virtual courtroom to rename themselves with their first and their last name, please. By going to the top of your little screen, there's a blue dot. If you hover there, that has three dots. You pull down on it and it'll say rename. I can do it, but let me ask you, sir, I have a Mark. The gentleman listed as Mark. Can you tell me who you are, please?
Yes, Your Honor. I'm trying to fix my name. Mark Pierce with DJC Law, here for Jessica Pettis. Apologize for being late. We had a confusion on who was covering this hearing.
Okay. Pettis versus Daniel Stephen, American Wind Transport and Stephen Family Farm. And do we need Miss Pettis? I need her to turn on her camera, please. Thank you, Miss Pettis. All right, who's ready to proceed?
Your Honor, I'm happy to take the lead.
Thank you. Go ahead, Mr. Dow.
Before I call the witness, just to give you a little bit of background, the genesis of this case is an accident that occurred December 14th of 2021, in which Amelia sustained some injuries. The settlement is for $100,000, and after the deduction of attorney's fees, case expenses, and some medicals, The net recovery is just, well, it's $59,171.48, all of which is being used to purchase a structured settlement through Pacific Life that will pay out annually from age 18 to 23. And so if you have questions for me, I'm happy to entertain those, or I can start asking Mom some questions.
Yeah, how old is the minor child?
7.
Okay, now.
7 now, yes. I guess when this happened, my math is not
3.
great. It would have been 4 or 5.
7 minus 14. Okay. All right, go ahead. Ms. Pettis, would you
And Ms.
please raise
Perez, you are the mother of.
Yes.
Okay, y'all were involved in a crash on December the 14th of 2021.
Yes.
Okay. My understanding is that Emiliano was in a car seat in the back seat. Y'all were northbound on FM 973. As you slowed to make a right turn onto Schmidt Loop, you were rear-ended by the named defendant. Is that all accurate?
Yes.
And that impact caused your car to spin around and hit a guardrail.
Yes.
Okay. Now, Emiliano had some injuries, correct?
Yes.
He was taken by EMS to Dell Children's Hospital.
Yes, that's right.
They did a bunch of imaging on him, all of which was negative.
Yes.
Okay. His complaints were a headache, and he had an abrasion on his forehead, correct?
Yeah, that's right.
Because of that, you had him follow up at Synergy Pain Management, and also because you saw excessive sleepiness in him, correct?
Yeah, that's right.
Okay. You also took him to Child Neurology Consultants of Austin to make sure that his brain was okay.
Yeah.
And then last, he got some treatment at Austin Injury Medical as well.
Yes.
And my understanding from the medical records and from visiting with you last week is that Emiliano is doing well now and has no problems or deficits from this accident. Is that accurate?
Yes.
Okay, good. Now, you engaged your attorney and his law firm, made a claim on your son's behalf, and settled that claim for $100,000 pending Judge Mauzy's approval. You understand that?
Yes.
Okay. And you've had a chance to review the breakdown, but let me kind of run through it, okay?
Mm-hmm.
You understand that after the deduction of a 1/3 fee, some case expenses, and the repayment of medical bills, the net to your son is $59,171.48. Do you understand that?
Yes.
Okay. You also understand that because Emiliano's 7, we can't give him that money. We have to do something with it until he turns 18.
Yeah, I understand.
And that something that we chose was a structured settlement through Pacific Life.
Mm-hmm. Yes.
And it's going to pay out as follows. When he turns 18, he'll receive $20,409.24, and that payment is going to recur for 5 years. You understand that? Annually for 5 years.
Yes. Mm-hmm.
Okay. So that the 59 and some change turns into just over $102,000.
Yes.
Okay. Now you stated earlier that Emiliano's doing well.
Mm-hmm.
Yes.
Yeah. Mm-hmm. Yes.
And you understand that you don't have to settle your son's case. You could reject this offer and instead go to trial. You have that right, as does your son.
Okay.
And you understand that a jury could potentially award him more than 100, but the flip side is true, and they could hear the case and award him something less than $100,000.
Yes, I understand.
And you understand that by settling this case today, you're waiving that right to go to trial for both you and your son.
Yes, I understand that.
And you understand that if Judge Mauzy approves this, that Neither you nor Emiliano will be able to make additional claims against this defendant or the defendant's insurance carrier down the road.
Yes, I understand.
You're comfortable with all of that. You believe that this settlement is in your son's best interest.
Yes.
And you're asking the court to approve it?
Yes, please.
Ms. Perez, thank you. I'll pass witness, Your Honor.
Mr. Pierce, do you have any questions for Ms. Pettis?
No, man, I don't think I do, Your Honor.
Ms. Posey?
Yes, Your Honor, just a few if I may.
Sure.
Ms. Perez, you had the opportunity to speak with Mr. Dow about the settlement for your son, is that right?
Yes.
And do you believe you received sufficient advice from your attorney as well as Mr. Dow about this settlement?
Yes.
In accepting this settlement on behalf of your son, you're in no way relying on anything that the defendants or their attorney have told you, is that right?
Right.
And you are not accepting this settlement for any reason other than it is in the best interest of your son?
Yes.
And you're not agreeing to the settlement purely to obtain money now to spend on things on behalf of yourself or your son, is that correct?
Yes, that's right.
You had a chance to review the settlement release on behalf of your son?
Yes.
And you signed that settlement agreement, is that correct?
Yes, that's right.
And again, you're asking this court to approve the settlement on behalf of your son?
Yes.
Thank you, Ms. Perez. I have no further questions.
Ms. Pettis, let me ask you, are you, is that your son's father involved in his life?
Yes.
Are you married to your son's father?
Yes, I'm married to him.
Okay. Thank you. Anything else?
I believe so.
I don't. I'm sorry. Sorry, Mr. Pierce.
Go ahead. No, that's all.
Okay, Mr. Dow, go ahead.
We have a final judgment. We're just needing everybody to sign it. And then I've been having some trouble with Box. I'm happy to email it to.
I prefer not to go to Box anyway. It's easier for y'all to send it to my submission email address. I don't know if we have the Box link set up anyway. So
would you prefer it to the email where the link came from or to your submission email?
my submission email.
Okay.
It's easier for me to get to it than to take it out of the box and get it signed.
Okay. And while we're here, Mr. Pierce, Ms. Posey, may I sign on y'all's behalf with your permission?
You do have my permission to do that.
Yes, Mr. Dow, I have actually, everyone gave approval. I've signed on behalf with permissions and I did upload it to the box. We can send that same copy to the submission email though.
Great.
Okay. Thank you very much, Ms. Pettis. I'm glad that Emilio is doing well. I'm glad he didn't have any more severe injuries and that y'all were able to reach an agreement. I will approve the settlement and I will sign the order as soon as this is presented to me. I assume the order takes care of Mr. Dow's fees as well.
It does, Your Honor.
Okay, great. Thank you all very much. You may be excused.
Thank you.
Thank you.
0 Sustr versus ATX Tillery and Meandering Bend LLC. Do I have everybody I need here? And I
Yes.
was confused. This is the case where there are some objections. I was looking at your pleadings.
Yes, Your Honor.
Okay. And that is contained in the defendant's response, correct?
Yes.
All right. Since we're going to take a record on this, let's go ahead and for the record formally state your appearances one more time, please.
Attorney Jennifer McGeorge for the defendants, Meandering Bend LLC and ATX Tillery LLC.
Wendy Chen on behalf of plaintiff Paul Sustr.
Okay, and Ms. Chin, it's a little better, but I just need you to speak up when it's your turn, okay? Because you sound pretty far away. Maybe turn up your volume. All right, let's take up the defendant's objections on the record first.
Thank you, Your Honor.
If I may.
Excuse me? Ms. Chin?
Your Honor, if I may,
Yes.
we had filed objections on defendant's summary judgment evidence today. Those were indeed uploaded to the box.
To the extent they were filed today, I haven't seen them, but they have to be, the replies have to be on file 3 days before the hearing.
Replies, but objections don't, do they, Ms. George?
I just haven't seen them, so I don't know.
Your Honor, my apologies, but defendant's response wasn't on file with the court until yesterday afternoon.
Well, it was filed and they received a copy of it timely. It just had some formatting issues that the clerk rejected it for, so we refiled using the same envelope to get it back on file from the objections. But we know that the plaintiffs saw it because they immediately the next day responded to something we wrote, and that was that there was no notice of hearing for the no evidence summary judgment on.
I'm gonna have to go get my book, but it is, Ms. Chin is right that it doesn't show a file mark until yesterday.
Right. We finally got it formatted in a way that it was accepted. The file mark should date back to the original date of filing though, because we use the same envelope.
It doesn't. Filed yesterday.
Well,
we read my
it was accepted by the court yesterday, yes. But it was served. It was served on the plaintiffs timely 7 days in advance of the trial or the hearing, I'm sorry. So,
well, I think that can be, Ms. Chin, you want to point me to the rule? I mean, can I go forward? I think it says on file, not whether or not it got to the plaintiff.
I can show you the e-filing envelope from the timely filing. It just, for some reason, the first clerk rejected it, saying that it had formatting issues. I actually didn't change anything about the envelope or the document and just resubmitted it, and it was accepted the second time. I'm not sure what was happening the first time. I can pull it open and show you that it was.
Again, I don't think that mattered. I mean, I'm looking, Ms. Chin, do you want to help me? What rule should I be looking at?
I believe it's Rule 21A.
Ms. Chin, I really am having a hard time hearing you. You have got to speak up and get that closer to you.
Your Honor, I believe it's Rule 21A. Sorry, did that go through?
I don't think it's, I'm looking at the summary judgment rule. It's 166AC, I believe. 166AC says in pertinent part, except on leave of court, the adverse party not later than 7 days prior to the day of hearing may file and serve opposing affidavits or other written response. File and
it was served, whether or not the court accepted the filing. It was filed and served that day. So they did get service of the document. We're just talking about when the court accepted the filing at this point, but it was filed and served timely.
It's not filed until it's accepted for filing.
I understand what you're saying, Your Honor. I'm just saying physically we went through the motion of filing it, and then we ended up with the Thanksgiving holiday, and so things got a little bit delayed.
Yeah, I'm concerned under the plain reading of the rule, your response wasn't on file 7 days in advance, which I didn't put to when I was looking at this file. I do think, backing up, Ms. Chin, in your notice of the no evidence is not properly noticed.
And I do have some points on that, Your Honor, because I heard you taking it up in the prior case. There are 4 cases on point that say that the notice itself of the hearing, you're supposed to have 21 days notice of the hearing itself. And that comes from Lewis versus Blake at 876 Southwest 2nd, 314, page 316.
Tell me this side again.
It's Lewis versus Blake, 876 Southwest 2nd, 314, beginning at page 316, out of the Texas Supreme Court, 1994.
That's what I thought you had to have notice, not just when it's filed at the hearing, which takes care. That helps me for my other case.
Yeah, I was kind of waving in the background while you were saying that, thinking,
Well, see, I knew that's kind of what I thought. And I'm like, that doesn't seem right to me. All right.
Your Honor,
Yes, Ms. Chen.
my apologies. The notice did say motions for summary judgment in the title, although when listing the motions itself, it declared that the plaintiff's traditional motion for summary judgment was on file, but unfortunately, the title of the motion, the notice included motions for summary judgment. And then
right, and the
we had
motions
filed
are
amended motions with the certificate of conference that we had conferred with opposing counsel on the dates and the setting of the hearing.
But in response to that, Your Honor, the motions are entirely separate documents filed separately. And then even the no evidence was, I believe, amended at a later time. And when I received notice for the traditional no evidence, I just assumed they wanted to take up the no evidence motion at a different time because it's a separate document. That's what we had notice of.
Well, it seems to me that you both have significant problems with today's setting. On the one hand, Ms. Chen, I've looked at the notices. I did see that when I was reviewing the file this morning, that you have two different notices. The first filed on October 24th says notice of setting on traditional motion for summary judgment. That doesn't put your opposing counsel on notice that you're going to proceed with your no evidence. You then filed on November 27th, which is not long enough before this hearing, a notice of in-person setting for the no evidence. So I don't think you can go forward on your no evidence. I also think, Ms. McGeorge, I don't know why the clerk sent it back, but you tell me that it was back in November or October that you filed it, or hold on, I looked.
November 26th, Your Honor.
November 26th, but it didn't get on file till December 2nd.
Yes, Your Honor. So on the 20th,
the requirements of.
So typically what I'll be able to do is call the clerk and point them to the original envelope, and they will change the filing date because it was rejected just for formatting issues. And when you use the same envelope, it usually keeps the same filing date. I don't know what happened in this particular instance, but
I don't either, and you don't have that envelope here. So here's what it looks like to me. Ms. Chen is not properly set on her no evidence motion for summary judgment. As I see the file, you don't have a proper response on file. And you say, maybe you can call the clerk and they can get a date from when it was originally filed, but that's not what I've got before me. So here's the what we can do. We can reset everything, or y'all can agree that everything can be heard. I'm not going to force you. Nobody needs to. But you both got issues today.
I think it's probably better to reset it so that we can take up both motions at the same time, since.
Well, and so that the appellate court doesn't say that your response was not timely filed.
Well, yes, honestly, yes, that too. I do think that I can contact the clerks and get them to switch the filing date per the.
Does it matter if you're going to have to reset it?
No, Your Honor, not if we agree to reset it, which I have no objection to.
Ms. Chen?
I'm fine with moving forward today on everything.
Well, we can't I can't move forward with everything. I can't move forward on your no evidence. And I do see that Ms. McGeorge has a certificate of service on November 26, which would have been proper notice. She tells me as an officer of the court that you received it that day. But unless we have some agreement that you're going to accept the filing dated December 2nd, I'm inclined to reset it.
Your Honor, my, if her response that may or may not have been timely filed it's a response to the no evidence motion for summary judgment. If that is the case, and then.
No, it's response to both.
Yes, Your Honor. Then my offer is to try both by agreement, because if I agree that the response was timely served, if not maybe timely filed, then I would prefer to try both by agreement.
And Your Honor, I'm not prepared to argue the no evidence right now. I did, out of an abundance of caution, put a response to the no evidence in there because I wasn't sure if the court would agree with the notice issue or not. But I will be honest, it's not the best that it could be or the most robust, because it wasn't what I was focused on in filing this response. So it was just an abundance of caution. So for me, I don't think we can waive the objection to going forward on the no evidence.
Well, I suspect if you don't waive that, Ms. Chin's not going to waive what she perceives or she's arguing is your late filed response. And again, I hear what you're saying, that it was filed and that you could get an envelope from the clerk, but I don't have that before me.
Yes, Your Honor, understood. But that means we'll just be back in front of the court on a motion for reconsideration with all of that evidence in front of the court. And we don't, I mean,
it makes sense. You both have enough problems that, and as these things go, they often go up in my ruling, and I don't think either of you are properly set on everything, and it doesn't make sense to piecemeal it or to be back on a motion for reconsideration. Because Ms. Chin, what if she gets the evidence and it does look like you were served, you had a certificate of service saying it was served on you, unless you're telling me, Ms. Chin, that you absolutely didn't get it before Thanksgiving.
No, Your Honor, I don't deny that it was served, but I was relying on the file stamp for the response. If it had not been accepted by the court, then I wouldn't have responded.
All right, I think in an abundance of caution, I'm gonna tell you all you need to reset all of this, because I'm not going to go forward, Ms. Chin, on your no evidence. It's not properly noticed. I do think, as I've said repeatedly, Ms. McGeorge has a problem with her filing. So as much as I hate to do that to you all, you're going to need to reset.
Thank you, Your Honor.
Understood, Your Honor.
Why don't you all confer and you can get with the court administrator. I don't know if you're going to be able to get another reset before the end of the year. Maybe. I don't know. You can't unless everybody waives the 21 days. You're going to look to January. Next week's a jury week. You can't get a setting anyway. And the week after, I think we only have dockets, if I'm right, on the 23rd. So y'all are going to be looking at the new year. Yeah, that's right. Next week's a jury. Well, no, you might be able to look at the week of the 16th if you all want to. Yeah,
I don't have any objection to waiving the 21 days and shortening it.
If you don't want to do that, I would suggest you call the court administrator to make sure you could get reached. Are you guys, let me look, are you both in town? Do you practice here or are you from out of town?
I practice in Houston primarily, but I do have lawyers at the firm that are in Austin as well.
Well, the reason I ask is we work on a central docket here, and whether or not you can get a setting that you'll get reached. What I'd hate for y'all to do is to get it reset and then not get reached. So if you want to make that agreement and get it heard the week of the 16th, the court administrator says they can get you reached. I'm going to make a docket note that if you do that, it should only be set if you all come up with an agreement to waive 21 days notice to make sure we comply with the rules. Okay.
Okay, thank you, Your Honor.
Thank you all very much. Sorry about that.
That's
I
okay.
haven't spent a fair amount of time reading these motions before today, so.
Oh, well, hopefully we'll not have to redo it next time. Maybe we'll
All
get you
right.
again.
Thank
All
you.
right.
You all may be excused. Thank you.
Thank you, Your Honor.
Have a good one.
You as well.